Hello, my name is Nicole Gallop Mildon and I'm a solicitor and diplômée notaire at Sykes Anderson Perry Limited, a firm of solicitors in the City of London. We have received many inquiries from trustees following the introduction in France on the 31st of July 2011 of new legislation relating to trusts. There is now a definition of what falls within the scope of French taxation as a trust, and various taxes now rise specifically on trust assets. It is important for trustees that they are fully conversant with the provisions of the legislation in France, including any amendments which may occur in the future. There are extremely onerous personal liabilities and consequences for trustees if they fail to observe their reporting taxation requirements. The French definition of a trust is very wide, and it includes discretionary, non-discretionary, revocable and irrevocable trusts. For the purpose of French tax, a trust exists where rights have been created in a country other than France, whereby assets have been placed under control of an administrateur for the interest of one or more beneficiaries, by someone who falls within the definition of a constituant, which is roughly equivalent to a SAPlaw. A constituant can either be the physical person who has settled assets into trust, or, if the trust has been settled by a corporate body, the physical person who has placed assets in the trust. The wording is such that a dummy settler is likely to be looked through. It is therefore possible that there can be cases where no physical person meets the definition of a constituant, and therefore, according to the statutory definition for French tax law, there is no trust. However, this is very limited and likely to be the case only where trust arrangements are set up by companies for the benefit of their employees. Indeed, company pension schemes are expressly excluded. It is possible for the beneficiaries of the trust to be treated as the constituent if the actual constituent has died. If neither the constituent nor the beneficiaries are resident in France, then the French trust rules will only apply if any of the assets are French situs. There is no definition of when an asset is situated in France or French situs. However, as a matter of guidance, it is our view that a debt owed to the trust is probably not French situs asset if owed by a non-French resident, even if it relates to French property. However, a debt secured by a mortgage over French land probably is. A debt owed by a French resident to the trust will certainly be considered a French situs asset. Once you have a trust that falls within the French trust legislation, there are a number of consequences. In particular, wealth tax, inheritance tax, including lifetime gift tax, income tax and the reporting obligations on trustees. There has been a form of wealth tax in France since 1982. Currently, it is based on the net value of taxable assets held by individuals on the 1st of January each year, and it is taxed in incremental bands. In essence, any French residents are charged this tax on their worldwide assets, and any non-French residents are taxed on their French situs assets only. There is a particular exception relating to the first 5 years of residency in France. With the new legislation on trusts, the constituent should declare the trust assets and make the relevant wealth tax return as if the assets were his own. If they do not do this, the French tax code provides that the trustees must declare the assets, and the trust is subject to a special wealth tax charge at 1.5% on all assets held within the trust. The charge also includes all the beneficiaries, not only those who might be deemed to be a constituent. If there is a French resident constituent or beneficiary, this then applies to all worldwide assets, but where the constituent or beneficiaries are not resident in France, the charge will be limited to French assets. If the assets are declared by the constituent or disclosed by the trustees, and the value of the constituent's net wealth is below the wealth tax threshold, there won't be an actual charge. However, there is an obligation to declare the assets even where the net value is below the threshold. The position in respect to French inheritance tax has changed significantly following this legislation. The old French approach meant that frequently there was no owner of the trust assets, and therefore on the death of the constituent there was no taxable event. Now all assets are considered to be owned by the constituent, and therefore there are potential charges to French inheritance tax. These charges apply to any gift or death which has occurred since the law was introduced on 31st of July 2011. A gift by the trustees or the death of the constituent is the event that generates a tax charge. How the tax is charged depends on the facts. The tax is either based on the family relationship between the constituent and the beneficiary, or in some cases it is a global charge. The charge is based on the net value of the assets gifted to the beneficiary. Where the constituent is French resident at the relevant date, worldwide assets are called. Where they are not, only French situs assets are subject to the charge. Where there is a gift out of the trust to a specified beneficiary, the taxation is straightforward. The taxation is as though there were a direct gift from the constituent to the beneficiary. French gift and inheritance tax rates do vary depending on the relationship between the donor or deceased and the beneficiary. If the gift to the beneficiary occurs at the death of the constituent, then the trust assets and the non-trust assets received by each beneficiary are added together and taxed at the ordinary rates. There are two scenarios where a global charge arises, and when this is the case, it is the trustees who are liable to pay the French inheritance tax. If on the death of the constituent the assets are not distributed and the trust simply continues for the benefit of the beneficiaries, there is an ad hoc global charge to French inheritance tax at the rate of 60%. On the other hand, if on the death of the constituent the trust assets are to be distributed globally amongst the beneficiaries but without stipulated shares for each party, there is a global charge to French inheritance tax at 45% with no tax-free allowance. For French income tax, the French tax code states that any income distributed by a trust to a French resident beneficiary is taxable income. There is, though, absolutely no provision which deems the income of the trust to belong to the constituent or any of the beneficiaries. Turning to the reporting obligations, these requirements apply to the trustees. The trustees are required to declare the creation, modification and revocation of any trust if the constituent or any beneficiary is French resident, or if any trust asset is situated in France. Declarations are also required when assets are added to or removed from the trust. The declaration must be made within 30 days of the event. The trustees are obliged to disclose the terms of the trust as well. The legislation provides for a public register with details of all the trusts, their beneficiaries, etc. For trusts in existence before or on the 31st of July 2011, a one-off declaration was due by September 2012. Subsequent declarations are going to be required for later creations, modifications or revocations. On the 15th of June each year, the trustees must declare the market value of the assets held by the trust as at 1st of January of the same year. The trust assets to be declared will be the worldwide trust assets if the constituent or any beneficiary who is deemed to be the constituent is French resident. Otherwise, the trust assets to be declared will be the French situs trust assets. Failure to declare will result in fines of €20,000 or 12.5% of the worldwide trust assets. The constituent, beneficiaries and trustees are held jointly liable to pay this fine. In addition, trustees, the constituent and beneficiaries may be liable for criminal sanctions. If the French tax authorities deem that there has been fraud, including voluntarily failing to file, then criminal sanctions may be applied. The criminal sanctions are a fine of €500,000 plus a 5-year term of imprisonment. The criminal sanctions, including the criminal fine, are in addition to any tax sanctions. If the fraud takes place as part of a group and/or involves a series of aggravating actions, these criminal sanctions are increased to a fine of €2 million plus a 7-year term of imprisonment. And yes, the use of a trust for tax evasion is considered to be an aggravating action. In summary, trustees need to regularly review whether trust assets include French situs assets and whether the settlor and/or any beneficiaries are French resident. If they fall within the French tax framework, they need to seek expert advice to comply with their obligations. Please don't hesitate to contact us if you wish to obtain such advice. Thank you.